We are going to court today in Massachusetts for a number of motions hearings, including the hearing regarding the defense tech expert. The prosecution made a motion to exclude. We're going to talk about that because it's like a motion to have a motion. And so we're going to go through all of the emotions of all of these motions in Massachusetts. And because that's where we're headed, we should just really, well, get right into it. At the end of the hearing that took about a half day this morning, the court addressed numerous topics. I was pleasantly surprised that the judge actually brought up the defense's motion with regard to their expert payment or request for expert expenses. I covered that earlier this week on Tuesday. That is the motion where the defense said, Your Honor, we sent our expert all the way to Massachusetts to download the original data off of the Canton Police Department DVR system that governs all of the motion-activated cameras around the police station. And lo and behold, when we got there, there was no original data on the DVR. So our expert flew to Massachusetts and spent their time at Canton PD trying to get information out of the system. And there were no logs, there was no original data. And they refused to provide us with anything. They said it's already been provided to the defense. But then there's no metadata left with regard to that video. So the defense has said, we can't ascertain how this shit got flipped, why there are timestamps missing, because we can't see when the activation of the motion capture was activated on, activated off, how the system was working. We can't see the logs of who accessed the system and when. And we wasted our expert's time, and the defendant should not have to bear that expense when the Commonwealth told us, yeah, your expert can come out and get this information. And because you did not tell us accurately that that information was gone, we wasted our time and money. And the court asked how this happened, essentially, and said, I am wanting to understand what arrangements were made specifically for this egregious error to occur. I would be very surprised if the court does not grant that motion for costs. The court wanted more of a breakdown on what exactly was agreed between the defense and the prosecution for this to happen. The prosecutor said this seems like it'll be a pretty simple motion to address when they were talking about addressing it next week in court. The judge also seemed to indicate at the end of the meeting for a meeting or the motion for a motion that the court really doesn't seem to expect that there is going to be a Daubert hearing. The court said, I think this is more a matter of the expert's opinion. Cue Tamara Judge. That's my opinion!
That's my opinion!
The court seemed to indicate it. Yes, it seems like this is a difference of opinion. However, I am going to review the Commonwealth's argument about methodology and then have an order out by Monday at the latest. Because if there is an order that comes out by Monday at the latest, the defense has to fly their expert to Massachusetts by Thursday and get their expert there for a Daubert hearing by Thursday next week. So the court seemed to me to indicate that there probably won't be a Daubert hearing. I will be surprised if the judge asks the expert to come in for a Daubert hearing. It seemed like the court was trying to figure out what else they would do with the court time they'd set aside on Thursday, including asking the defense if they would be ready to discuss their motion to dismiss. The defense was disinclined to acquiesce to that request and said, we need more time to file our motion to dismiss. We will be filing a motion to dismiss, but it will not be filed before Thursday. The court said, be prepared to discuss it. And then the court set out other dates for things like the motions in limine, motions to suppress, and the rest of it. The defense said they're not sure exactly what they'll be filing yet because the discovery is not done from the Commonwealth. The Commonwealth indicated that they have a new accident reconstructionist, that there is a neurologist that they are waiting on a report for, that there was a new witness interview, and that there's a new report from their digital expert, Hyde, and that there is another report regarding a different cell phone. So there is still more information being given from the prosecution to the defense going on into next week. So the defense said, until we have all their information, we can't do our work until they do their work, and they're getting it to us on Wednesday. And then we need that information to go forward and finish our work, our motion to dismiss, the motions in limine, any motions to suppress. The motions to suppress will be regarding mostly new information, but could be regarding old information, anything that shouldn't come in trial. And then the motions in limine will be narrowing down what evidence will come in or stay out at trial. And we'll see those motions in limine made. Those motions in limine, some of them are going to mirror what happened, I'm sure, at the first trial. Those motions need to be made again to preserve the issue for appeal when this trial goes forward. Some of those will probably be incorporated from the last trial. Your Honor, we made these motions in limine and we incorporate those into the record, and the court will rule what they will rule. But we might see new motions in limine with regard to new information that was turned over by the prosecution. And what we heard from the prosecution today is, look, I have been digging through this discovery to make sure the defense has everything. I went through and Bates stamped, which keeps track of every page of paper that's turned over in order, regardless of what report number it is or what page number it is. It's all stamped in order and turned over. And the prosecution said, look, I went back through, this is the new special prosecutor, Brennan. I went back through and Bates stamped everything to make sure that everything that we thought had been turned over, everything new has been turned over. And we have a way to keep track of it, which wasn't done before. And I was like, what? How do you know what hasn't been turned over if you don't have record of it? So it seems that Brennan, though I don't always agree with all of his arguments, has been trying to diligently go through all of the discovery to make sure the defense has it, which is at the minimum what should be done and should have been done before the first trial. And we've seen the defense note in several motions that things were just not turned over to them. And no matter what you think of this case, no matter what you think of the lawyers, their arguments, the judge, or any of it, at a minimum, there should be zero hide the ball in criminal court. Everything should be turned over. And it's clear from the motions that there are things that had not been turned over in a timely fashion, and that is an issue. I'm waiting to see the motions to dismiss and the response to see how much of an issue that is, but it's an issue. Things should be turned over. And there shouldn't be a guessing game over whether or not you have all of the discovery. And it seems that the new special prosecutor is playing catch up in that regard to try to make sure that it is. That's got to be incredibly frustrating for not just the new prosecutor being like, WTF is this? And for the defense being like, when are we going to be surprised that there's just something else that we didn't get? That is not how any of this process should work. So however you feel about the case, and I know there's people who think that the defense has reached beyond the sun, and there's people who think that the defense is absolutely dead bang right. It's not the defense's job to prove anything at the end of the day. It's the prosecution's job to prove their theory of the case to a jury. And did they do that in the first trial? Well, no, they didn't prove their case to the jury, as evidenced by the jury's non-decision. But you have to make sure the defense has everything. Otherwise, the consequences can be severe to the prosecution. And we saw that in the Rust case. Will this be the same situation? I don't know. I want to see what the defense has to say in their motion to dismiss. There's going to have to be a weighing of what evidence the defense is argued was not turned over and or was destroyed, including the metadata from the original video from the DVR. Could that metadata have been preserved had someone done it right? Those are things that are going to come up, I imagine, in the defense motion to dismiss that they have indicated their filing. So we've got time to see what happens ahead of this trial. And we will see. We are also still waiting to see if the Supreme Judicial Court of Massachusetts rules. They are still pending on the issue of whether or not the jury reached verdicts on 2 of the counts at the first trial. So there are a lot of things, outstanding in this case. And it's really somewhat overwhelming, the amount that is still outstanding with how close they are to a retrial. Retrials are often not this busy in between the first trial and the retrial, because normally it's hey, this happened and now we're doing it again. So we've got a lot that was on the docket today. The court brought up the issue of expert-related expenses and wants a little bit more briefing on that. So we will see more briefing from the defense with regard to the emails back and forth with the prosecutor. The prosecutor was notably restrained, saying we can explain. I think the prosecutor's explanation is this shouldn't have happened. I don't think we're going to see the prosecution fighting much about the expert fees. That would be my guess. Today, we saw argument regarding whether or not reporter Gretchen Voss's notes need to be turned over or redacted. It seemed to me that the court indicated some of the notes do need to be turned over, some will be redacted, and that the court reviewed those in camera and was given them this morning, which would account for why the court was running maybe 20 to 30 minutes late if the court was reviewing those before coming out. And if you hand the court something before they walk out on the bench, they're going to take time to review it. So that doesn't surprise me. We also saw a brief discussion of the discovery with regard to the ARCA experts. These are the experts hired by the federal government, not by the defense or prosecution in this case. And what discovery needs to be turned over with regard to them, that is still pending. And then the motion to either have a Daubert-Lanigan hearing or exclude, and the court's going to rule on that by Monday. Thanks for joining me. If you enjoyed this episode and don't want to miss updates on your favorite cases, you're going to need the Law Nerd app at lawnerdapp.com. That way you can stay in the loop on the cases that matter most to you, and you never know when you're going to catch feelings for a new case. So make sure you get it for free on iOS and Android. Thank you for being here, and thank you for being a Law Nerd.